Welcome, and thank you for joining us for Pride in Our Legacy, Planning for a Future of Justice. It's wonderful to be here with all of you. I'm Carole Allen-Scannell, GLAAD's Director of Development. I've been here for just over 6 months, so there are still a few of you that I've yet to meet, and I am really looking forward to changing that, particularly when we're back to seeing one another in person. Before we get started, a little housekeeping. Live captions will be provided. You can turn those on by clicking More and selecting Closed Caption. And we will be recording this panel as well as the Q&A later on. If you don't want your name to be recorded, you can rename yourself or opt not to use the chat or the Q&A functions. So there will be time for a Q&A at the end of the session. And if you want to ask your question out loud, you can use the raise your hand function or the chat to let us know, and we'll make it so that you can ask it out loud. Otherwise, you can click on the Q&A button at the bottom of your screen and type your question there. You can also upvote questions that others post that you would like to have answered too. That'll help us put them in priority order. Finally, I want to thank our GLAAD Legacy Society members for hosting this event. This is a thoughtful group of individuals who have provided for GLAAD in their estate plans. And if you are interested in supporting GLAAD's critical work with a plan gift, reach out to me anytime, or you can visit the website, which is glaad.org/legacy/society. And of course, don't forget to follow us on Facebook, Twitter, and Instagram. Okay, we have a lot to talk about today, so I'm going to ask our panelists to briefly introduce themselves to you. And I'm not sure what order we're showing up on your screens, but I'll ask Annika to start us off.
Sure. My name is Annika Bockius-Suwyn. I'm an estate planning and estate administration attorney at DangerLaw in Newton. We work with a very diverse population, but we have a primarily LGBTQ focus. And so I'm happy to answer any questions about the fun stuff like preparing to die.
Okay, Lisa, will you
Certainly, thank you. I'm Lisa Cukier. I'm with Burns and Levinson. I'm a family law attorney, and I handle a range of issues that relate to different types of life cycle matters from the time a person's born, even before then, until after a person dies. And that includes family relations, divorce, estate planning, dealing with blended family planning, prenuptials, and issues relating to sibling disputes and intra-family disputes. So my value here is to talk about how to make sure that what you want, what your intentions are, can be truly met, and that you're safeguarding against pitfalls and problems, because that's the type of work that I do, is to troubleshoot against it, protect against it, or help people if they're in the middle of difficulty in their relationships.
And that leaves you, Matt.
Hi, I'm Matt Gibson. I am at John Hancock Insurance in Boston, and my role is on the distribution side of the house. So I spend most of my time working really closely with our distribution partners, so that be that either insurance agents, insurance advisors, or the distribution intermediaries that they work between. So I spend a lot of my time working on the actual product development of what we actually bring to market and ultimately protect your families with.
Awesome. Well, thank you all for being here with us. Just to give you everyone a little bit about the format, I'm going to be asking our panelists a few questions, and then we'll open up to your questions. And as I mentioned, you can do that either with a live question or putting your question in the chat. So with that, I'll start off with our very first question, which is, what kind of gifts make the most sense at different stages of life? This is something that folks have had an interest in knowing about. So I'll open that up to whoever would like to answer first.
Would you like me to give a few ideas about it?
Sure, that'd be great, Lisa. And last time I went in alphabetical order, so we can popcorn this.
Okay, that's fine. So I think that when people go through different life cycle issues, they should be thinking about estate planning. They should be thinking about the people who they have a sense of obligation for. In our community, our families are not necessarily blood family. In our community, we may have relationships with people that last longer than our marriages to them last. We may have all kinds of different configurations. We may have children who are not ours by biology or adoption, who may be step family or maybe not, whom we feel a need to protect and look after and support. And we have all different kinds of relationship configurations. It's never ending, and it's very important that the relationships that we value are valued in the plans that we make. And along those lines, in our community, we have a very significant history and a deeply held commitment to benefiting various charities. Every year, we are all thinking about our giving priorities. It's something that separates our community from other communities. There are other communities that do the same thing, but I have to say, we have a track record of thinking long and hard about which giving priorities we're going to live with each year and what we want to do and making our dreams become a reality. So in terms of the timing of gifts, I would say that estate planning should be discussed with your estate planning lawyer anytime that you have a significant life cycle issue, a birth, a death, a marriage, a separation, a cohabitation, anything. Whenever there's anything of significance, you should discuss it with your lawyer and make a decision at that time based on many different criteria. It should always be in flux, but it should always be discussed.
Oh, I obviously agree. You should call me all the time. But, you know, for me, I see clients at a whole range, but just like Lisa was saying, of their life cycle. So I have a lot of new parents who come in, not really with a lot of cash to spare to make gifts. And so there's the really easy stuff you can do with your estate planner, like just putting in a small distribution in your will to a charity that you feel strongly about. For people who really can't spare any to take care, they need it all to take care of their kids right at this second. We make a charity, what I call the meteor scenario. If you're all hanging out in your house and a meteor hits it, who's going to get your stuff? Do you want it to chase your long lost relatives, or do you want to really create a legacy? And that's, for GLAD's purposes, not super helpful in terms of planning, but for people, it starts to help them think about giving and about that being part of your estate plan. Then, of course, there's also bigger changes like setting up larger donations that you want to fund something particular or fund a legacy out of a trust or out of your will as you get later in life. But I think there's a middle ground that a lot of people don't really get involved with, which is where you can start really using charitable giving both to help the groups you want to support, but also to help yourself. So, you know, with our IRAs, a lot of people saved really well for retirement, and all of a sudden they saved so well for retirement, they have all this qualified money that they're not going to need. There's a ton of easy choices for that. There's leaving leaving a charity as the beneficiary of your IRA, so they don't have to pay any income taxes on the distributions from the IRA. You can leave your cash or your stocks to your family members, who only have to deal with estate tax then and not income tax. Even more immediately than that, though, if you're getting all these mandatory distributions from your IRA, and that's just adding to your taxable income and not necessarily benefiting you, then you can either give that donation to give that income from a distribution to the charity, or just through your IRA yourself, make a qualified charitable distribution. And that's very similar to, there's a whole range. You can do stuff like planning, that's very like just in case. I'm going to give this term life insurance policy that I don't need. I'm going to make a charity the beneficiary. I'm going to make I don't need this IRA to live off of, so I'm going to make the charity the beneficiary. That's long-term, kind of the just in case stuff. But if you really want to see the effects of the work that you're doing in the moment, there's great stuff like qualified charitable distributions, like I talked about, donor advised funds where you can teach your own, as you kind of come into your own wealth, you can teach your children and your grandchildren about how charity is a huge part of your culture and of your family. And then there's simple stuff like just giving a stock to a charity, to GLAAD, preferably, in order to avoid the capital gains on it, because GLAAD doesn't pay the capital gains. The market is growing like crazy right now, so it's a really easy way to avoid that capital gains on a small section of something. And then everyone likes to talk these days about, called a CRUT, because my area of law has just amazing acronyms that sound terrible. It's a charitable remain unit trust, and it allows you to put a certain amount of money into this trust and avoid the income tax on this, and you get a certain payout over your lifetime. And then once it gets to a certain point, it terminates and gives the remainder to a charity. So there's so many good flexible things that either an estate planning attorney, a financial advisor can help you get into, just to like benefit yourself and see your legacy now and plan for maybe an even greater legacy after you're gone.
I mean, it's funny that you kind of talked a little bit about, obviously using the term insurance policy as an example. I mean, from a life insurance perspective, there's generally, broadly 3 ways you can use life insurance to make a gift to a charitable organization vis-a-vis GLAAD throughout different stages of your life. I think the first one is obviously just simply naming the charity as a beneficiary of a life insurance policy. That could be one that you got independently through an advisor that you work with, perhaps one that you have at work. Now, where that may work differently in certain kind of stages of your life, if you don't have any immediate need for kind of like the traditional life insurance planning, where it's like, oh, I just got some insurance from work. Maybe you're not married, maybe you don't have any dependents or any large amounts of debt that you're concerned about covering upon an early passing. You could simply declare GLAAD as the beneficiary of that. There's no rules against doing that. Additionally, you also don't have to name the beneficiary in an absolute 100% basis. You could do it even as a simple 10% of the total, 5% of the total, 50% of the total. It's entirely up to you. And generally speaking, it's not a permanent change. So if your needs do change down the road, and you do now have children that you want to, maybe you change that percentage adjustment up or down, depending on the situation as that goes forward. It's not an irrevocable change you can make, though that can be something you can do, but I would urge you to have the type of a conversation with Lisa and Annika forward for that. The second one is really just simply donating the entire insurance policy contract to GLAAD and gift the entire policy to GLAAD. Now, from that point forward, generally the charity pays the future premiums, but there's nothing inhibiting you of gifting the premium on an ongoing basis going forward from there. So just simply transferring the policy in that capacity is there, and obviously working with an attorney to determine how that type of tax deduction gift may work with you is going to vary based on your existing plans and the ownership structure that may already be in place on the policy. And the third one is one that a lot of people don't think about. It's usually due to the fact that it's actually buying a new insurance policy on your own life or on your spouse's life, whatever the reason may be, at the point in time with the charity as the owner at day one. And I apologize, my dog is now banging on the back of the door of the office. Welcome to remote presentations. But in those situations, the only kind of nuance that you need to kind of keep in mind is, generally speaking, if you want to support a charity during your lifetime in that structure, you need to establish generally some sort of pattern of ongoing support and involvement to essentially determine what we in the industry refer to as insurable interest, which basically means that you need to illustrate that there is a clear loss from GLAAD in the event of you passing early, be that either your key role in fundraising, donating, whatever the case may be. Doesn't have to be purely monetary, just needs to have some sort of monetary equivalent. That could simply just be support. So if you're on a board of GLAAD or a similar charity and you no longer being able to participate in that capacity, is an insurable interest that is important to protect to make sure that GLAAD can continue their operations in that capacity.
I'd love to add to that to say that there's a few inflection points when you might want to be thinking about this. Sometimes you can use this creatively to get out of conflict. So sometimes you might be involved in a, God forbid, a divorce, and you can't decide how assets should be distributed, and there may be some kind of conflict and impasse. Think about designating a portion of it to a mutually agreed upon charity, because that is the way to get out of that impasse and to move beyond that in a way that satisfies all goals and keeps the relationship and the individuals feeling good about it. You know, another inflection point is in estate litigation. Sometimes there is estate litigation, somebody dies, they've made a gift, and people are disputing, you know, what to do about the gift, and perhaps they feel that they should have had more. Well, one way to resolve estate litigation or trust litigation or sibling disputes is to figure out what kind of a gift everybody can participate in, and to use some of the funds from the estate towards that gift by using what's called a compromise agreement or a non-judicial settlement agreement, either for a will contest or a trust litigation, respectively. There's different ways that you can manage to make a gift rather than stay involved in litigation. So think of those inflection points not only to speak with your lawyer, but also as a means to get to yes and get out of litigation.
Well, thank you for all of that. There are two questions that are related to this that I'm just going to bring in now as opposed to waiting until later. First is, can the required minimum distribution from an IRA be given directly to a donor advised fund with no tax consequences?
No, so the qualified part of a qualified charitable distribution doesn't count towards a donor advised fund, which is interesting to me because many of the donor advised funds are 501c3s. Fidelity likes to talk about how they're the world's biggest charity right now, which is something. But unfortunately, no. You would have to pay the income tax to send it to a donor advised fund, but you would not have to pay because it's your required minimum distribution. There's no penalty for taking it out or anything like that, but you do have to pay the income tax on it.
The other question has to do with appreciated stocks. And the question, which I can answer this one for you, the answer is yes. Can I donate appreciated stock to GLAAD?
Yeah.
So anyone else want to add anything to that about, the tax benefits of donating appreciated stock?
I mean, just on a very simple thing, the qualifying we're all going to say is if you're doing things for tax purposes, please talk to your CPA.
Thank you.
Everyone's tax situation is very different, but in general, the advantage to donating appreciated stock is that if GLAAD then sells the stock, they don't have to pay capital gains on it, and you don't have to pay capital gains on it, and you get the charitable donation deduction.
I will say you are seeing more and more of that happening in the current market, particularly with certain sectors having incredibly high returns. Now seeing people with really maybe over-indexed portfolios, all of a sudden they're like super overweight on tech because they went heavy into Amazon or Peloton and other things that just kind of exploded over the last 12 months or so. Getting that out of an estate from a growth perspective using a charity is one strategy. And for those of you who may be feeling uncomfortable moving a stock that you may have no intention of using that money during your lifetime, you can benefit GLAAD today. And then there is an insurance strategy of actually covering the existing value within the estate. So if you're worried about not being able to leave that asset or the equivalent of that asset to your children or other family members or whoever else you may want to leave that to, you can essentially insure the gap that you're now providing outside of that, because that is an asset that's yours and important to cover as well.
Okay. Moving on now to a related topic is what pitfalls should people avoid when making a planned gift? Is there anything in particular that you would note?
Yeah, so pitfalls is what I do. I it's that's pretty much it. So one of the concerns that I would have if people want to prevent a pitfall is if you're making a will or establishing a trust and you're doing your estate planning and you're making gifts that are going to be distributed later and not gifts that are made outright and at that moment during your life, but that are going to be distributed after your death, then you want to think about who are your heirs and the beneficiaries and who may be out there that may not like the choice that you made, and whether you want to take some steps to protect that choice within the documents themselves. So one way to do that, if you're anticipating a contest, let us know. Your lawyers can help. So if you were to let me know that you anticipate a contest or you anticipate that somebody will be displeased with what you've done in any way, not only relating to the gift, but with anything relating to your will or your trust or your testamentary instruments, if you anticipate any discord at all after your death, then let us know, because we might put in some interesting language in your document, such as what's called an in terrorem clause. That's Latin for in terror. It's a clause that forfeits the heir's right to take anything if they contest. And when you use this kind of clause, you want to offer some money, some benefit, so that there's something to lose by contesting. Or you could have language in your documents that has exclusionary type terms, which says, I've excluded you not because I don't love you, I've excluded you because I've provided for you during my life, or something like that. But when nothing is stated in the will or trust or whatever that testamentary disposition is, when there's no language in there to give it context and to give it meaning, if there are heirs or beneficiaries who are displeased by anything in there, there could be a contest, and that would hold up the gift that runs in favor of the charity. And it could actually put into question the charity's ability to get the gift or to get it timely, even though the contest may have nothing to do with the charity. So when you're speaking with your lawyer, contemplate, troubleshoot, anticipate, think in advance. That's one type of pitfall you want to deal with. Another one that I deal with an awful lot, since I practice family law and divorce, as well as prenuptial planning and blended family planning for the next chapter, is very often people will not reconcile their separation agreement from their divorce, along with their prenuptial agreement that they're for their new marriage, and then they start to undertake estate planning. And nobody has looked at all three documents and reconciled them. And I can't tell you how often I've ended up in court with parties who are in discord because something is inconsistent or some plan was frustrated by the creation of a new document and the best intentions go south. If you're making a gift, the last thing in the world that you want to have happen is for it to fail. You don't want that to happen. You want to do it, and you want to do it right. It's a one-shot deal, and it's got to be done perfectly. So when you go to your lawyer, you want to show all the different documents so that you can make sure that no matter what happens, that gift is protected and is not subject to be to fail, subject to be frustrated by new documents.
Thank you, Lisa. Any other thoughts on planning that it doesn't work?
I mean, I think from an insurance perspective, the short answer is waiting. The simplest answer is waiting. And that's just because of we'll call it the four-letter word, which is medical underwriting. Generally speaking, from a broad perspective, the longer you wait, the older you become, the more expensive an insurance contract tends to be, as well as the risk that you end up developing some sort of medical condition that complicates the underwriting process. If you are going to be acquiring a new policy to either cover an existing donation. So for example, as I mentioned before, you were transferring a block of stocks to GLAD, or if you actually were creating a new life insurance policy with the intention of the full death benefit or portion of that proceed going to GLAD. So waiting that process is a big part of it. I will say, it feels like it's the big elephant in the room. COVID over the last 12 months has really materially affected the life insurance industry. I would actually argue potentially for the better, particularly when it comes to the consumer perspective. And the reason why I bring this up is the traditional model for insurance, you have to go through a medical underwriting process. As a result of COVID, more and more people just were not comfortable getting medically assessed, particularly early in the pandemic, didn't feel comfortable going to their doctor's office. So insurance carriers, John Hancock being one of them, essentially changed a lot of our new business processes to actually force the companies, the carriers, to really meet consumers' needs where they were. So not requiring medical examinations if they weren't required under certain circumstances, being able to issue a policy without traditional underwriting oversight within that. There's been a lot of medical enhancement as well to that. I will say one of the things that comes up pretty regularly when I'm talking to friends and other members of the LGBTQ community, a lot of it really is systemic, really from the 80s and even 90s. Even if you happen to be living with HIV, many insurance carriers will write coverage. I think there's this big notion of, if I have a pre-existing condition, anything from living with HIV to even something as more commonplace as diabetes, it does not exclude you from being able to acquire life insurance, which then you can use in the planning strategies that Lisa and Annika are talking about, or even just simply, I'm going to buy it on my own and give a portion of the proceeds to GLAAD or a charity. So that's just something I just want to make sure is out there. I don't think that is particularly commonly known in the kind of the more parlance of the average consumer, because there's a lot of conflation between medical underwriting for life insurance and even medical underwriting for health insurance. They're very different beasts. Life insurance tends to be a little bit more progressive in that approach.
Also, in terms of pitfalls, this is a simple one, but I think a lot of people really like the idea of the gift being like a surprise for the charity. When they pass away, all of a sudden we have this giant legacy, and I get that. But even if you ask your attorney to sort of do it anonymously and not talk about the number, it's really good to talk to the charity about what language they might want. Are there things in that district, and some charities I talk to are like, whatever, you're fine with whatever you put in. But some charities, especially higher education, but in general, have very specific language that they want put in. And so, yes, also it's just good to tell the charity so they can do some planning, not so that they can, throw a party at your funeral, but from a, just so that you make sure that, again, that it flows as smoothly as possible. Don't create an avoidable problem. So it is important, I think, to tell the charity that you've, or at least ask for language.
We appreciate it. And then we can also celebrate you while we can right now. So I'll just say that on behalf of GLAAD, we love to know when people have included us in their estate plans. It's really quite nice. And as some of the people that are in on our webinar today know, they really do make a difference for what we are able to accomplish. And the legacy that you leave is the legacy of justice. So I'll leave it there. Also, there are a few more questions in the comments, but I'm going to hold those for later and just get to this last piece, which is my last question for you all, which is, can you tell us about a situation where you work with a client who benefited from gift planning? Let's go in reverse order. Matt, will you start us off? As soon as you unmute yourself, it'll be much better.
There we go.
There you go.
All right, I'm like hitting the button, it's not working. Sorry. So while I don't work directly with consumers, I do work very closely with our distribution partners and insurance professionals that do this type of planning regularly. And I think there's a lot of examples about how this kind of planning is important, and Annika and Lisa have talked about that. But I'll use myself as an example, and this may be a good kind of transition to talk a little bit with Annika. Both my husband and myself are actually clients of Annika's. We've had really great conversations and sometimes kind of hard conversations about what just our general planning ends up being, but also what part of our planning is going to include charitable planning. And really, I think one of the best things you can do is really just like rip the Band-Aid off and have the conversation. We've created this almost stigma in society about like how we don't talk about finances, and sometimes not even with your partner or your spouse, or if it's, as Lisa mentioned, your chosen family, it's this taboo that you don't have a discussion about. And having a attorney or a financial advisor or an insurance professional that can encourage you to have that important conversation and just remove the stigma around it is really just the first step of doing some of that planning that you may be looking to do. So I may actually just suggest Annika kind of take the ball here. And again, I apologize for kind of surprising everybody. Surprise, I'm Annika's client, but surprise, I'm Annika's client.
Yeah, so I think Matt can tell you that at least in DangerLaw, talking about your estate plan is not scary. You might even laugh.
We did.
You might even see a dog. If you want, nobody's gonna force a dog on you. But yeah, for me, like, I don't have any necessarily specific stories, except just to see client say, oh, wait, I can leave a portion here. I have so many clients, especially in the LGBTQ community who don't have children, feel like, oh, well, I inherited this money from my parents, so it should go to my nieces or nephews. It should go to my siblings. And that's fine if that's what they want. But in terms of both legally and sort of morally, there's no obligation there. So if instead there are charities that you want to really honor either during your lifetime or upon your death, just seeing that sort of revelation of, oh, I don't have to give everything back to my niece and nephew who barely write me. I can create both my own family, but also some charitable giving that means a lot to me, and I can create a legacy that way. I will also say, right now, I don't do a ton of estate tax planning and preparation because the Massachusetts estate tax is not terribly onerous, and the federal is at 11.6. So there's a lot of stuff you can do to avoid that, like during your lifetime. And I didn't do a ton of on death right now. That being said, I do anticipate it going down at least somewhat in the next 4 years. And so charitable giving is also a great way if you're on the cusp of some estate tax getting hit with the federal estate tax. There's a lot of planning that you can do to lower your taxable estate and still have a great legacy for your family members and your friends, but create the double advantage. There's a lot of great advantages we're talking about. There's the feeling great about helping a charity and feeling great about saving money on your taxes. So, which is also an appropriate topic for February.
I think in answer to the question, one of the greatest joys that I have as a lawyer is assisting as trustee and helping people decide where they want to place their money and how they want to do good in the world and how they want to repair the world and make the world a better place through their funding and giving priorities. It's one of the most joyful aspects of my law practice. In addition to adoptions, it's just very gratifying to be able to make those choices. And it gives everybody a strong sense of feeling good about what they're doing, feeling good about putting their assets to good use and doing the right thing. When I serve as trustee, I ask people to let me know, my clients, I ask them to let me know about their other priorities, not just giving priorities, but the way that they may raise their children and their values, their principles, their judgments, the way that they view the world. The clients who I'm doing this kind of planning with they become friends. We tend to socialize. We get together annually. We'll go out to dinner. We'll sit and we'll talk and we'll have significant conversations about family, about family dynamics, about giving, about philanthropy, and about doing good in the world and repairing the world. And it's a very joyful and meaningful aspect of practicing law. And I know that my clients like it very much. I think they feel that they are doing something to save the world, which they are. And they're when they can make their philanthropy and their philanthropic goals turn into reality, it's incredible. And I just want to mention one thing that was said by you, Carole, that it's good to be able to talk in advance with the charity about the gift in advance. It really does make sense. You know, I've got clients who decide that they want to make a gift and they want it to be for a specific purpose. It is so important to speak with you about that, because my clients need to know whether the purpose they have in mind is realistic given the structure of the different programs that you have. And they want to make sure that their funding is going to go in the way that they intend. And so having that dialogue in advance of drafting is very important. You may have provisions that you want me to include in the draftsmanship that we're doing. And so I need to know what those provisions are. And so there's a great benefit to that philanthropic communication and the dialogue.
Mm-hmm. It's also important too, I think, this is kind of a pitfall, and also playing off what you said, Lisa, is, you know, talk to the charity, because maybe somebody else just pledged a huge amount of money to the exact same cause, and all of a sudden we're overfunded for something that isn't a problem, maybe because we put all this we've made huge strides. I think the example Carole used when we were talking about this earlier is, you know, in a few decades, if we've eliminated HIV completely between prep and education and other scientific advances, like, what if people are leaving money just to help the HIV positive community? Well, eventually, hopefully, there will be none. So being able to make sure that both with the charity side, that you're funding things that make sense, but also with your attorney and the drafting, that you're making the gift flexible. To say, this is what I would really like it to go towards, but if certain conditions exist, it can go towards this, or it can be used for general funds. Obviously, the charities like as few strings as possible, but as your attorneys, we want to make sure that your wishes are fulfilled.
Yeah. And I've seen some really great language that allows flexibility on the part of the organization to use funds based on the donor's intent. But if we don't know what your intent is, that makes it much more challenging.
Absolutely. And this is why when I serve as trustee, I like to really understand the intent. And if it's a married couple, I want to hear from both and get to know both spouses, because usually one spouse dies ahead of the other, and there may be different issues that come up. And so I like to meet with both and really get to know my clients who are charitably inclined, so that I can be sure to carry out wishes after both have passed away, or to assist a spouse who's now a widow or widower.
All right. Well, I'm going to jump into open up the Q&A. People have been putting questions in, so we'll get to those first. But if you do have a question, feel free to either raise your hand or type it in, and I will allow Mads to give me the heads up if there are live folks that want to ask questions. Anyone? Okay, so I'm going to start off with the question that came in and said, you have not said anything about charitable annuities. Does GLAAD offer these? What's the panel's opinions of this option? GLAAD does offer these. So I'll let the panel weigh in on charitable annuities.
I guess I'll jump really quickly, because I guess an annuity is technically an insurance product. So I think there's, at the end of the day, there isn't anything wrong with charitable annuities at its core. It obviously depends on your individual plan, your financial plan, that type of stuff. Of course, blanket disclaimer. I will say, I think a lot of the intent behind a charitable annuity can be accomplished in some other ways that tend to provide a little bit more flexibility to the donor. Obviously, when you create an annuity like this, you are irrevocably releasing a large amount of funds traditionally at the get-go. of that, determining on if you get income from that. There is obviously tax on that income stream that can be a little bit of a challenge. But if you're creating that annuity for income, there are generally better, efficient ways to actually create a non-charitable annuity to receive the income yourself. That being said, I would probably, in most scenarios, tend to see things like charitable remainder trusts be created instead of doing a charitable annuity, just for the flexibility component that oftentimes provides. It's a little bit more of a sophisticated strategy, so I would really urge you into having a conversation, perhaps jointly with an FA and an attorney like Lisa or Annika, to kind of walk through that more specifically. But just a broad-based answer, there's nothing negative about charitable annuities at its core, but there are often more flexible planning strategies that tend to be a little bit more common nowadays than others, just for the flexibility that can provide you as the donor.
I don't have anything to add to that. Matt, you handled it. You pretty much said exactly what I would have said.
I will take that as the highest praise, Annika.
Likewise, I have nothing to add.
Okay. So I will toss this one out there. Can you talk about the pros, cons of picking a lawyer from a small office versus a large group, especially if we might have 20 to 30 years of life left, could anticipate a lawyer retiring, et cetera, before we do?
I mean, so I'm from a small firm, so I'll start there. So I think you really have to go with what makes the most sense for you right now. I think trying to plan to have the same attorney 20 or 30 years from now, that would be great. But there's so many factors as to what could happen between then and not. And if your attorney retires, they have an obligation, if they're holding your documents, they have an obligation to say, hey, I'm retiring, or hey, I'm dropping out to go live in Fiji or whatever. And I've picked this law firm here to be my successor. If you don't want them to be your successor, shoot me this card back or an email and I'll get you your documents and you can pick a new attorney. So I think more important than whether you're into a big firm or a little firm is whether you feel comfortable with the attorney for this process right now. Like I know at DangerLaw, we have 3 estate planning attorneys, but we're in a growth space. There could be more later. There could be less later. I don't know what the economy is going to do. But I think it makes more sense to pick for now, because yes, you might still have the same firm in 20 or 30 years. If it's a bigger firm, that's more likely maybe to be around, but it's not necessarily going to be the attorney you have a relationship with.
Yeah, I think that's fair. I think it really boils down to fit. You need to know that you have a good fit with your lawyer. My firm has about 125 attorneys, so it is a larger firm. One of the advantages with a larger firm, not that it's a reason for you to choose a larger firm, but one of the advantages is if it is a firm that is a full service firm and you have multiple different needs that are multidisciplinary. We've got our tax specialists. We've got our international tax specialists. We have our business law and corporate lawyers. We have insurance lawyers. We've got estate planning lawyers and significant depth in prenuptial planning and divorce law, custody law, parentage issues, and adoption. So as well as IP and other issues that occasionally come up. So if your foundation, your family foundation, or your estate planning needs involve corporate interests or more complex tax law matters, then perhaps having a firm that is a one-stop shopping might be helpful. Also, if there is a blended family situation with perhaps a divorce or two in history, or perhaps there are other family issues that require a family law attorney, then having that specialty in-house can be helpful. But I don't think the age of the lawyer really is a matter. That's not going to be the issue, because in your estate plan, whether you use a small firm or a large firm, your estate plan can absolutely have a plan for succession of your trustee. In my firm, what we say is that if the attorney who was selected, let's say, for example, I've been selected as trustee. Let's say that I pass away and I'm not available to you to serve as trustee when you need it. Well, the estate planning instruments that we draft will say that the 3 senior most equity partners from our firm will select a successor in perpetuity. So there's always going to be somebody, our firm's been around for 65, 70 years. There's always going to be somebody who can step in, or I could designate who's going to be my successor, so that if something's happening and I feel like I can't serve as trustee at some point, but that can be done at any firm, regardless of the size, regardless of the age of your fiduciary. So it really boils down to your fit with your lawyer and whether the firm has the capacity for what issues might arise.
Thanks so much. 2 more questions. One just popped up, and I'll ask this one now. Is a planned gift to a charity done through a will, or does it require establishing a trust and/or more advanced estate documents?
You can do it in a will. It might not be, and it might not be the most efficient thing for you personally, or for your heirs, but there's nothing wrong with a will. You can just have a simple will that leaves things to a charitable gift, as well as your friends and family, whomever you'd like. A will, very old type of document, happily gets the job done, not quickly, but it gets it done. So a will is sufficient.
And I'll just point out that there are answers to some of these questions are actually on the GLAD website. So I'm going to put that in the chat for folks, just so you have it too. It's glad.org/legacy-society. So you can check out some of the information that is there. And I'm going to get to the next question, which is, what's the best way to leave a charity the proceeds from the sale of my primary residence and an investment property? This would, of course, be upon my death. And I will make that an or, because we do have both, where people are looking to leave us their primary residence or an investment property. And I'm not sure if the 2 are different, but if you can handle them separately, then I'll open it up.
So obviously everyone's situation is going to be a little different, and there might be other things involved that would make me lean one way or the other. But my general thing is a living trust. Keep control of it for as long as you'd like, unless there's some sort of mass health planning that needs to be done, but that's not the topic of today's talk. I love living trusts. They skip the probate process, so I just dunked on wills for being really slow. In trusts, we can be really sad in the morning and give away your stuff in the afternoon. We'll still be sad when we're giving away your stuff, obviously, but there's a lot of flexibility in a trust that you don't have in a will necessarily. There's no court oversight, and honestly, probating real estate in Massachusetts is an actual nightmare right now. So by putting it into the trust, we skip the probate process. Your trustee can move things into, sell and give the proceeds to whatever charity and however you'd like. So that's sort of the most broad general answer. There's obviously a lot of other creative things that we can do based on the rest of your needs and what your goals are for your kind of overall plan. But that's sort of my gut answer. I don't know if yours is different, Lisa.
No, I have nothing to add. Thank you.
Okay. So I think most people have been putting their questions in the chat. Does anyone have a live question that they would like to ask? Okay, barring that, there's one more. Is there a difference with LGBTQ planning versus straight planning?
Yes. At DangerLaw, we call it the President Pence Clause. And it is what happens if the government, and this is particularly for married couples, What happens if the government decides that you're divorced, but you don't? His divorce does have legal ramifications on your estate planning documents, and we want to make sure that we're protected against that. That's more of a joke now than it was perhaps in November 2020 when my clients cringed when I said that, but it is what we prepare for. And especially around parentage as well, we have special language that says, a lot of documents, old documents, and you should check if you have old documents or if your family members have old documents, only define descendants as by blood. And then if they're a little older, maybe blood in adoption. There's actually a third level that I like to include, which is by law. So a lot of same-sex couples in Massachusetts, if they're married, they have the presumption of legal parentage. And if they don't take steps to then make those presumptions sort of more fail-safe, they're just parents by law. They're not parents by blood, and they're not parents by adoption. So I like to make sure our definitions are as broad as possible. There's also other little things. LGBTQ families are more likely to be estranged from blood relatives. They're more likely to have, like Lisa was talking about earlier, more complicated relationship patterns, still wanting to honor former spouses, former partners, former stepchildren, all these sorts of families that we build. I always joke with my clients that your divorce will eliminate your current spouse as your healthcare proxy. So if you still want your ex-spouse to be your healthcare proxy, you need to sign it again. And when I say that, straight clients laugh, and queer clients are like, yeah, that makes sense. So that's sort of on its face. You can go to any estate planner and use any estate planner. They'll get the job done. But for the nuances, there is some important stuff to do.
I agree. And keep in mind that, it wasn't until 2004 that we could start getting married. And so there are a lot of people among us who, and all of us were acculturated to think that we would never get married. That was always just the starting point. But, there are many people who had relationships that predate 2004 that were non-marital relationships, and who may have children from those relationships. And there's a lot of expectation, obligation, anticipation, and that is very different. It's a distinguishing factor about our community. The people that we have as our family are chosen, but not always recognized, and that distinguishes us. And so our estate planning is so important. It is really critical to do what we're doing right, because the pitfalls are enormous and are greater than in any other community. Keep in mind that, sure, we may have marriage now and there may be marriage equality, but there's still great discrimination and inequality, inequity. And so when we are dealing with our intentions for how we want our assets to pass after we're not around, and when we're dealing with our intentions for who's going to be a beneficiary of our wealth, we need to make sure that we are doing this with expertise and lots of forethought, and with protection against the discrimination that does still exist.
And the only thing I would add is briefly on more or less on the underwriting capacity of how life insurers look at, at the end of the day, we look at risk. That's the way we evaluate risk. We are pretty blind to sexual orientation. You actually can get a survivorship policy where 2 lives are covered. If it is the same gender, that's not a problem, which then also begs the question of gender identity on an application. Generally speaking, the industry still has applications that have male, female. Usually that is referring to the gender assigned at birth. That's mostly just due to the actuarial calculations that are going on behind the scenes. But most carriers, John Hancock being inclusive of those, are very sensitive to gender identity and to how we communicate with individuals. So if you are a he, him, his, or they, or whatever you want to have on your communications, that can be usually accommodated at the insurance carrier level. And as I mentioned before, because of course the HIV community is still over-indexed within the LGBTQ community, that is something that does not disqualify you as being eligible to purchase life insurance. Of course, it does depend on your method of control, if you're undetectable or not. There are certain kind of qualifications for that medically, of course, but that is not an immediate knockout from many insurance carriers for that. So if that is something that you are concerned about, have a conversation with your advisor to figure out what carrier may be an appropriate planning avenue for you.
Awesome. Okay, so we have a live question.
Hi, everyone.
Hi, Bob.
Several years ago, I designated a family member to be the executor of my estate. And in subsequent years, it became apparent to me that she was a fan of having a president who was orange. And so I want to change that designation. I've considered other family members and close friends, and for either political reasons or fiscal irresponsibility reasons, I don't have a candidate that I would be comfortable with. What does someone do in that situation?
Well, often I advise my clients in that situation, and I do have several clients in that situation, is that a trusted professional, so a CPA, an attorney, to some extent, there's been some rules recently changed for financial advisors. Not all of them can serve in that capacity, but some can. And it's worth talking to someone about that. Like Lisa said, she serves as trustee or executor. I'm named in several documents, or other estate planning attorneys at my office are. So I find in that scenario, I mean, you can even name a bank. I will say that often the banks aren't very interested in smaller estates unless you're talking multi-millions. But so maybe an individual is a better way to go. But if you really can't think of anyone, a bank can serve. And also in terms of irresponsibility, if it's something like, it's something like they're just not great with money, but what you need to think about an executor is that they're the CEO of your estate. They don't actually have to do most of the work. They can hire an attorney to do it. And that's the other half of my practice. So I do a lot of it, and executors really run the whole spectrum to I'm doing everything. You just need to draft the legal documents so that I can have the power to sign things, to I need you to do every bit of correspondence. I'll just put my signature on things when you tell me to. So if you feel like maybe appointing someone who you don't necessarily think could handle it themselves, but could handle hiring an attorney, that's an option too.
You know, it doesn't have to be either or. It can be both. So many times I'll serve as trustee or as personal representative, meaning the executor of an estate. And I'll do that with a family member so that the family member can consult. And it brings it's less expensive because you might have the family member handle some issues rather than having the lawyer handle the whole thing. But it also gives assurances that everything's going to be done correctly by the lawyer. It gives the family the sense that they have participation, but it also makes sure that there's a professional involved as well as a personal trustee or PR. So it doesn't have to be either or, it can be both.
One more question. We're getting close on time here, so I'll do one more question, and then we'll our executive director, Jan Sumu, is going to close us out. So the last question is, what oversight exists for an attorney or CPA as executor, especially regarding expenses?
So depends on how the probate's going, but the general oversight is if your beneficiaries think that this person is racking up bills, they have to provide an accounting, they can challenge the accounting, and the court would step in if there has been kind of an abuse of the position. I'll also say most CPAs and lawyers, despite our reputation, are not going to risk their professional license to steal some of your money. Some do, but if you're already kind of in that place of a relationship with them, you know, for me personally, it is never going to be worth however much money it is, to no longer be able to practice law. Because if I get caught, I not only lose that, but I also lose the money, and it's a whole thing. So there are mechanisms to challenge what a personal representative or trustee is doing. But also, if you already have a good relationship with them, it doesn't happen quite as often as perhaps the movies would like you to think.
And there's some checks and balances too. So if you have a professional serving with a family member, there's an inherent checks and balance, because the attorney serving as trustee or personal representative is going to need to bring in the family member co-fiduciary to discuss expenses and to monitor accounts, and both people will be entitled to review the accounts. The other thing that we do is we put in accounting provisions into our wills and into trusts, and even sometimes durable powers of attorney, so that the fiduciary serving, if that person is a professional, you can encumber them with the obligation to account to the beneficiaries and to show every penny in, every penny out, or whatever it is that you want, and at whatever frequency or interval you choose. So there are those types of safeguards. Another safeguard is if you believe that the personal representative of an estate is not doing all that that person should do, you just make that suggestion to the court, and the court can supervise and have oversight, or could even remove and replace a fiduciary. So there are checks and balances out there.
All right. Jansen, I see that you're there, so you can take it away.
Hello, can everyone hear me?
Yes.
Well, let me just say thank you so much first to Annika, Lisa, and Matt for giving your time, your wisdom, your expertise on this really important topic. I learned a ton, and I'm sure other people did as well too. And then thank you to the Legacy Society for hosting tonight's webinar, and for being so generous and intentional about what type of future you strive to build for the next generation. Because I really believe what makes our community and our movement strong is that not only are we all beneficiaries of past generations who fought to create a more inclusive and affirming world for all of us, but we all have that same opportunity to build upon and pass that legacy forward. And so I just want to share just a few thoughts about what I think that future looks like and can look like. And, like just hands down, bottom line, it's a future where LGBTQ young people are not simply surviving, but they are thriving. And I want to give you one example of a boy named Kyle, who we helped a few years ago. Kyle is a gay 14-year-old boy who lives in rural Maine and struggled enormously after he came out, partly or primarily because of his mother's hostility to his identity. She cut him off from his support network, including the local LGBTQ youth theater out in Allied Youth Theater, which served as a safe space for him. She made fun of him. She made it clear that he wasn't, like, who he wasn't safe and supported in their household. And it got so bad that Kyle was hospitalized twice because he was worried that he would harm himself. And then it got worse. After Kyle was released from the hospital and back in his mother's care, she took his cell phone away, further isolating him from his support group. But it's thanks to the adults in Kyle's life who did support him, his grandmother, the executive director of the theater group, that Kyle was able to connect with GLAAD attorneys. And we successfully helped Kyle through the court process of having his grandmother appointed as his temporary guardian, given the risk that he was at in staying with his mother's care. And today, Kyle is safely living with his grandmother. We actually got a letter from the head of the theater group a few months later. And in his letter, he wrote, quote, "The support GLAAD and its attorneys have given Kyle has empowered him to more fully advocate for where he wants to live and who he wants to spend his time with." So thanks to support of the GLAAD community, Kyle is thriving today. And that's also thanks to all that you do to create that future and that legacy. So if you are interested in joining GLAAD's Legacy Society, please visit glaad.org/legacy-society. That link is in the chat. Or you can email Carole. Her email is also in the chat, but it's also on the Legacy Society page as well too. Either way, thank you so much for spending this evening with us, and we hope you have a wonderful rest of your evening. Take care.